Welcome back to the Center Square Daily. I'm your host, Greg Bishop. Now let's put Illinois in focus, with an Illinois Supreme Court case heard this morning in Springfield surrounding whether someone merely charged with a felony, not convicted of a felony, can have their firearm owner's ID card suspended or revoked. In a case heard by the Supreme Court in Illinois this morning, filing from the plaintiffs say even law-abiding citizens make mistakes, and at times the criminal justice system makes its own. The filing says, here, plaintiff's only mistake was traveling to visit his family in Cook County. The mistake the criminal justice system made was arresting and initiating a felony prosecution against the innocent person. While traveling, the plaintiff in this case had an unloaded firearm properly enclosed in a case and secured in the trunk of the vehicle in which he was a passenger. And the plaintiff's filing says, consistent with Illinois law, plaintiff also possessed a valid firearm owner's ID card, which he carried with him. This rendered his possession of his firearm fully compliant with statutory requirements. The vehicle was stopped, according to court documents, for a minor traffic violation, a cracked windshield, which is a violation committed by the driver of the car, not a passenger like the plaintiff in this case. The filing continues saying, following what appears to be standard police procedure, the officer who stopped the driver asked the plaintiff whether firearms were present inside the vehicle. The plaintiff truthfully answered, advising that there was an unloaded cased pistol in the trunk, and he produced his FOID card. Despite plaintiff's compliance with the various FOID statutes, plaintiff was immediately arrested and charged with carrying a loaded firearm without a valid FOID card. This felony accusation was facially untrue, the plaintiffs say in their filing, as the arresting officer knew the pistol was unloaded, secured in the case in the trunk, and the plaintiff possessed and presented a valid FOID card. Nevertheless, plaintiff's FOID card was subsequently invalidated, and from that instance, the plaintiff was prohibited from possessing a firearm anywhere in the state of Illinois. The filing from the plaintiff says federal law, however, did not require him to relinquish possession of firearms, but Illinois rendered his possession illegal. So that was a filing from the plaintiffs in this case, and in front of the Illinois Supreme Court Tuesday, arguing on behalf of the state, Carson Griffiths defended the FOID card law and said that the case should be remanded back.
This court should vacate or reverse the circuit court's judgment on either of two independent grounds. First, Bright's challenge to the temporary suspension of his FOID card is moot because his FOID card was reinstated in May 2023, and he did not make a clear showing that any mootness exception applies. Federal courts of appeals have issued several decisions that have uniformly upheld a similar federal law that prohibits the acquisition of firearms while an individual is under felony indictment. So those cases provide clear guidance to lower courts in Illinois, specifically as to the historical tradition allowing for the complete but temporary disarmament of individuals facing felony charges. Surety laws that allowed for restriction of firearm access to those reasonably accused of intending to breach the peace, and those could be entered on a finding of probable suspicion that an offense was intended, similar to the probable cause determination that accompanies felony charges.
Now, attorney Thomas Magg, representing the plaintiffs in the case challenging the FOID card law, he laid out what he says this case is really all about.
My client is a nonviolent person. He is a genuinely innocent man who was genuinely falsely arrested and genuinely violated of his constitutional rights. What we're challenging is the fact that they are deprived of the use of arms simply because ipso facto they are charged with a felony, any felony, no matter what the felony is, no matter what the evidence is. It's a total ban based on mere accusation. And there is no, other than the fact that, yes, you could lock somebody up, and the king did lock people up. That was one of the crimes of the listed in the Bill of Rights, potentially indefinitely. That's why we have a speedy trial clause of our Constitution.
Mag, he got questions from various Supreme Court justices this morning in Springfield, where Chief Justice P. Scott Neville asked about whether the case is moot because the plaintiff eventually got his FOID card back, and how this case fits into the public interest.
Technically, it is moot, but there are exceptions to the mootness doctrine that apply that allow this case to proceed.
Does it come within the public interest exception?
All right. Why does this come
So
with
how?
How? One, it's a matter of public interest. Constitutional rights are a matter of public interest. This is a state statute that is being enforced by the Illinois State Police that regulates a fundamental constitutional right. This is a matter that reoccurs routinely. This is actually the second time this issue has been in front of this court in the last couple of years.
Now, MAG also fielded questions from Justice Sanjay Taylor about what specifically is being challenged in this case.
So your argument really is that the statute is facially unconstitutional because it does not provide for individualized assessment of the defendant's dangerousness.
As applied through 922N, I agree with that, but there are other statutes that can be applied through Section 8N that do allow for individualized assessment, such as the mental health determination. But again, there is no historical analog to simply saying, I accuse you of a crime, therefore you cannot keep and bear arms.
So the Illinois Supreme Court justices taking that case under advisement, meaning they could issue a ruling in the weeks or months ahead. Now, the firearm owner ID card has been challenged in Illinois state courts for years and has been considered by the Illinois Supreme Court several times in the recent past, with outcomes leading to cases being sent back to lower courts and no true decision on the constitutionality of requiring residents to get the state's permission through a government-issued ID to exercise the Second Amendment right to keep and bear arms, which the Second Amendment says shall not be infringed. And that will do it for Illinois in Focus with the Center Square.